Welcome back, folks. Before we go back into court, I want to bring in our guest for this hour. Joining us here is trial attorney and host of the Once Upon a Time Crime in Hollywood podcast, Kelly Hyman. Kelly, great to see you again. Thank you so much for joining me here on the program. Let's talk a little bit about what we were hearing, right? A little bit of dysfunction. Let's start there. Within the defense team, and again, we understand that what the defense is trying to do is they're trying to claim that there was ineffective assistance of counsel. That's level one. Then they have to also show that that ineffectiveness affected the outcome of the trial. But we'll deal with that in a minute. Right now, I want to get your thoughts on the dysfunction that we're hearing about from this witness, one of the attorneys involved in the trial on the defense side, that was going on. What do you make of that? Is that something that's common? Is that something that rises to the level of, or at least partly rises to the level of suggesting the defense was ineffective?
That's a tough call, because when you look at this from the legal perspective, you think, okay, if there was an issue with the boxes, why not have an easy resolution, as we were talking about? Like, talk to the judge. Okay, Your Honor, the other side is not giving us the witness list. Can you please, before we go to the next day in court, give us the list of the witnesses so we can fully prepare? Or, Your Honor, make sure that we get all the boxes and bring them into court because we are having issues with delay. There's an easy fix, but is that enough? Just because they had to go across and get the boxes, enough to push the line as being ineffective assistance of counsel? I think that's a tough case.
Now, you've been on tons of trials. You had parts of trial teams, complicated litigation. Is that common, where maybe a couple of the attorneys, whatever happens, whatever the reason is, you don't get along, maybe they're not, you guys aren't talking as much? How much does that affect the representation of a client?
Well, definitely, but you have one quarterback. It's kind of like football, right? You have one person leading the charge, and then you have your other people doing certain things. So, for example, the one lead trial is making sure that everything goes smoothly and making sure the other attorneys have certain kind of tasks and certain types of jobs. So when I think about him testifying, saying that one person was objecting that she was worried about making sure that she had the binder, why doesn't someone go get it or switch it up and say, okay, you focus on the objections, or kind of have a strategy and come together? It's kind of like in football, you're looking back saying, oh, we lost. Well, it's because someone else's fault, pointing the fingers.
All right, quickly, 30 seconds. The other issue involving the judge saying that, and the one that I'm going to point out is the one where he says to him, your client needs to plead to avoid the death penalty. Sounds a little bit like bias there. This is during the trial. Judge seems to have made up his mind. That kind of struck me as a little bit odd. What did you make of it?
I was sitting here with my mouth almost open, saying, okay, you have allegedly a judge is presiding over a case saying that you need to take a plea deal. Now, the ethical implications of that are a whole nother Pandora's box kind of thing. But then I think, okay, if that's the case, then why didn't they file something with the court or do something to, you know, make that a record as well? But maybe they were concerned about upsetting the judge and having the ramifications of something really bad happening.
Yeah, they didn't seem to not like them already. But anyway, things are sort of piling up here. Let's go back into the court where we're watching the post-conviction relief. Guest still with us in studio is trial attorney and host of the Once Upon a Crime in Hollywood podcast, Kelly Hyman. Kelly, what do you make of what we're hearing? I mean, again, there's a lot going on here. There's a lot of little disparate parts that can certainly raise questions. Here they're talking about two of the people who confessed to this crime having inconsistent statements. If that doesn't tell the people who are investigating this that something's wrong, it should. Then they pressured one of them to change his statement, which he does. That gets into court, and again, the conviction happens. But this is what the jury saw, and this is the way it went. So I don't know what this judge is going to do. What do you think?
Sounds like the perfect storm. You have so much going on in this case. You have issues with counsel, ineffective assistance of counsel, not objecting. You allegedly have a judge watching a football game and telling a defense counsel your client needs to take a plea deal. And now you have people that are key to this case with inconsistent statements. So it's keep moving. It's like moving the goalie line. But is that enough for the judge to come back and say, yes, new trial? I don't know.
Here's part of the problem. Some of this stuff made it in front of the jury. So the stuff about the inconsistent statements and the fact that he was pressured to change his statement, some of that made it in front of the jury. They rejected it. There's also some information that's going to be brought in about cell phone records that suggest the defendant was somewhere else, and his brother. They said they were together somewhere else when this murder was supposed to have happened. That was in front of the jury. They rejected that too. So I think those are the things that are going to really work against this defense as they try to get a new trial.
That's a key point, because the jury are the trier of facts, and they heard this, and they can weigh the credibility of information that they hear and whether to give someone, you know, they believe them 100% or not to believe them as well. And the fact that they heard all this weighs in the favor of not giving a new trial.
And it's not the judge's job, correct me if I'm wrong, to substitute his judgment for the judgment of the jury who actually heard the testimony in court. He's hearing recants of it, but at the end of the day, they're the ones that heard the original testimony and made their decision. Not his job to substitute for their decision.
Right, he can't play the quarterback after the fact and look at it, but he can look at the fact of potentially ineffective assistance of counsel or something else going on as well, or potentially new evidence if in fact, you know, didn't get in, that it should have gone in. But making a decision after the fact and being the 13th juror, yeah, that's not going to work.
Tough. And without that actual statement recanting that thing or his testimony, he took the fifth, it's going to be a tough road for the defense. Kelly Hyman, thank you so much for joining me tonight. Always a pleasure to have you on.